Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
When you think about a company like PVH Corp, you're really thinking about global fashion on an unimaginable scale.
Oh, absolutely.
We're talking about iconic brands, Calvin Klein, Tommy Hilfiger. This isn't a small operation. It's a massive global lifestyle company.
It is. They're in over 40 countries with something like 27,000 employees. They are the definition of a large, sophisticated global enterprise.
And that's what makes today's deep dive so interesting. We're going to look at what happens when a corporate giant like that makes a huge strategic decision, in this case, a massive global reorganization, and how that decision holds up under the intense scrutiny of a federal court.
Exactly.
So our mission today is to dig into the court filings, specifically the order on a motion for summary judgment in the case of Linfante Hill v. PVH Corp. This is a 2025 decision out of the Southern District of New York.
And the conflict here is classic, but the details are just fascinating.
Right. You have a highly rated 54-year-old executive. She's terminated during a big company-wide reduction in force, RAF, but she claims that RF was just a pretext.
A cover story.
A cover story for age discrimination. And the smoking gun, she argues, is that just before she was let go, a younger employee was hired into a role that looked an awful lot like her old job with a new title.
And the location here is absolutely critical to the entire story. This case is being heard under the New York City human rights law, the NYCHRL.
Okay, so why is that so important?
Because that specific law is, well, it's famous or notorious, depending on your perspective, for its uniquely broad and remedial purposes. The bar for a plaintiff to make their case and get to a jury is just so much lower than under federal law.
So under federal law, the standard is usually but for causation, right? You have to prove AIDS was the reason you were fired. How different is the city law?
It's a fundamental shift. I mean, it's what makes this case so relevant for you, the listener, to understand. Under the NYCHRL, the plaintiff doesn't need to prove age was the only reason or even the main reason.
What?
They just need to show that age played at least some part in the decision. That means the employer, PVH, can only win before a trial if they can prove that discrimination played absolutely no role.
That sounds like an almost impossible bar for a company to clear if there's any conflicting evidence at all.
It is an incredibly high hurdle.
Mm-hmm.
And as we're about to see, the facts surrounding this particular reorganization made clearing that hurdle for PVH exceptionally difficult.
All right, so let's set the stage. Let's talk about the executive at the center of this.
Okay.
Her name is Christine Linfante Hill. She was hired by PVH back in October of 2017. She was 49 at the time.
Her title was Vice President of Business Process Management, or BPM. And you really have to understand, this wasn't some kind of, administrative role.
No, BPM sounds very central to operations.
It was directly tied to massive strategic technological transformation. Her entire job was about change. Her tenure at the company just speaks volumes about her seniority and her expertise.
So what did she actually do?
Well, she held major leadership roles. For instance, she was the head of the colossal SAP implementation for Tommy Hilfiger North America.
That is a monster project for any company. We're talking multi-year, multi-million-dollar undertaking.
It's huge. And she also led their transformation enablement unit. These jobs are all about making sure a global company can actually pivot, adopt new tech, and change its processes successfully. Succeeding at that, especially with something as complex as SAP, means you're an expert.
An expert in both the tech and the business side of things. You have to know how everything works.
Exactly. It's a foundational skill for a company like PVH. And her performance reviews really reflected that. This is a key point. This wasn't an employee who was on thin ice for poor performance.
Right, which can complicate these kinds of cases. So what did her reviews look like leading up to the termination?
They were consistently strong. In 2018, she was rated exceeds expectations. Then from 2019 through 2021, she got successful.
Which is still a very solid rating, especially during, the chaos of global retail in those years.
It is. And the most glowing praise actually came in her 2020 review. It specifically lauded her BPM team, saying they delivered several successful SAP deployments during the course of 2020 and did so despite challenges.
So managing major tech rollouts during a pandemic.
Yes, and the review called it truly an exceptional accomplishment, of which Linfante Hill contributed to. I mean, that shows she was operating at a very high level of competence.
So you have this highly valued, consistently successful executive deep in the company's most complex tech projects, and then in September 2022, she's terminated.
Right. And that sudden shift from high praise to a pink slip, that's what demands this kind of deep scrutiny.
Do we know who the key decision makers were?
We do. It was Eileen Mahoney, the CIO, and Lisa Kilgallen, who was the Group VP of BPM and Linfante Hill's direct manager. And this is interesting. PVH's defense immediately tried to use the ages of these managers as a shield.
Who so?
Mahoney was 7 years older than Linfante Hill, and Kilgallen was 4 years older.
Ah, the classic same actor defense. The idea being that since the managers are older, it's less likely they'd discriminate based on age.
Precisely. They're trying to say, look, there's no inference of discriminatory intent here. But the court, especially under that liberal NYCHRL standard, basically said that's not nearly enough to dismiss the case.
So the facts of the situation were more powerful than the demographics of the managers.
By a long shot. The factual conflicts and all the circumstantial evidence just overwhelmed any inference you could draw from the manager's ages. The context of her termination was just far more persuasive.
Okay, so let's turn to PVH's official reason, the reduction in force. The RIF, it started around August 2022.
Yes, and it was a massive company-wide initiative. And publicly, it was framed as a very necessary business decision.
And their stated rationale sounds, on the surface, completely reasonable.
It does. It was all about implementing a new global operating model, driving efficiencies, lowering costs. They'd even made public statements about reducing people costs by 10% in their global offices.
Sounds like responsible corporate governance.
It does. And their specific reason for letting Linfante Hill go was that her position had become obsolete. That's the key word. The claim was that the whole structure was shifting. Implementation work was moving away from her centralized global team and down to the decentralized regional teams. So they argued a global VP for that role was just no longer necessary.
Now, legally speaking, a RIF based on real economic needs and a structural change, that's a legitimate, non-discriminatory reason for termination, right?
It's the textbook example. It's the standard defense that satisfies the employer's burden in that McDonnell-Douglas framework we talk about. If PVH genuinely eliminated a role for business reasons, that's usually the end of it.
Unless
the plaintiff can prove it was all a lie. The second PVH offered up the reasoned obsolescence due to restructuring. The legal burden shifted squarely onto Linfante Hill's shoulders.
So she had to prove that the RIF as it applied to her was a smokescreen, a pretext.
Exactly. A pretext for intentional age discrimination. And this is where the company's timeline starts to fall apart.
This is really the pivot point, isn't it? The company is saying her role is obsolete, but why were they recruiting for a very similar position more than a year before the RIF?
This is the central contradiction that the court seized on. The search for this new role, Vice President, Enterprise Business Process Optimization, it began way back in 2021, long before the RIF, which was called Project Green, was even formalized.
And the purpose of this new role?
To improve BPM, specifically to lead the implementation of a new platform for modeling and automation.
Okay, but PVH's argument was that this was a totally different, highly specialized job that Linfante Hill just wasn't qualified for.
Yes. Her manager, Lisa Kilgallen, claimed that Linfante Hill did not have the business process modeling and optimization experience or certification they needed. This is their attempt to justify hiring someone from the outside.
But that claim immediately runs up against her proven track record of success in massive systems transformations.
It does. And then you get this huge factual dispute that a judge just can't decide on paper. He said, she said. That has to go to a jury.
The dispute over whether she was even interested in the role.
Right. PVH stated definitively that she did not apply for or express interest in the position.
But she says otherwise.
Her sworn testimony is that she did express interest to Kilgallen, and she claims Kilgallen told her she was not needed to interview.
Wow.
Think about what that means. If a jury believes her, that a high-performing VP expressed interest in a related new job and was actively shut down by her manager, that suggests the outcome was predetermined.
That the decision to get rid of her came first, and the skills gap story was invented later to justify it.
Precisely. It screams pretext.
And while this was all happening, TVH went ahead and hired the new guy.
That's right. Ilir Marino was hired for this new optimization role in September 2022. This is at the exact same time the RIF is being implemented.
And the age difference.
Marino was 47 when he was hired. Linfante Hill was 54 when she was terminated just a few weeks later. That 7-year age gap is absolutely central to her case.
So her legal team's main argument was that this wasn't really a RIF leading to an obsolete position. It was a replacement, just disguised with a new job title.
Yes, and they had the documents to back it up.
The paper trail.
The paper trail is where it gets really damaging for PVH. Officially, they argued Marina did not replace her. But under questioning, they had to concede he assumed at least some of her responsibilities.
At least some. That's a classic legal hedge.
It is. But even more telling, Kilgallen, her manager, directed Linfante Hill to transition all of her outstanding work to Marina.
You don't transition all the work of an obsolete role to a new hire.
You absolutely do not. Not unless that new hire is, in fact, taking over the function that the company still needs.
So what about the internal documents, the org charts? This is where the corporate story really meets the internal reality.
This is the smoking gun. Her lawyers pointed to PVH's own records, specifically a document, an October 2022 chart titled Global Business Process and Transformation Team.
So this was created right after she was let go.
Immediately after. And her lawyers argued successfully that this chart shows, visually and structurally, that Marina took over Linfante Hill's exact team, her direct reports, and her duties just under this slightly different title.
So PVH's own org chart basically shows a box with Linfante Hill's name being replaced by a box with Marina's name.
That's essentially it. It shows the new structure looked almost identical to the old one, just with a new person in charge. This is a powerful, factual punch right to the gut of their obsolescence argument.
It shows the decision wasn't about if the job existed, but who should do the job.
Exactly. And that brings us back to the qualifications gap. PVH's refusal to even consider her starts to look even more suspicious in this light.
Because she argues she had the experience they claimed they needed.
She did. She provided her resume, her performance reviews, showing extensive experience in business process modeling from past jobs and from her work at PVH. And here's the kicker. Kilgallen admitted she knew Linfante Hill had some experience in these areas.
So it wasn't ignorance of her skills.
No. The failure was the active decision not to inquire further, not to interview her, not to even consider a successful internal candidate for the role. That failure to even look at her suggests the decision was based on something other than pure merit.
So we have all these conflicting facts, a clear replacement, a questionable rationale. Now let's apply the legal framework to it. The McDonnell-Douglas analysis.
Right, the 3 steps. Prima facie case, legitimate reason, and then pretext. And we have to keep hammering this point home. It's all viewed through the incredibly liberal lens of the NYCHRL.
Right. Under federal law, this might be a much tougher climb for her.
Oh, absolutely. Under federal law, you might have to show the company's reason was totally false and age was the only reason. But here,
she just needs to show age was a motivating factor, even a small one.
Even just 1%. If a jury believes that 99% of the reason was the RIF, but 1% was age bias, that is enough for liability. Which is why courts are so reluctant to grant summary judgment to employers in these cases.
Let's take a quick break.
Hey, it's Mark, and we have a new product for you. It's called the Employee Survival Guide, or employeesurvival.com. And it's a site that you can obtain PDF products that I've created myself. I was spending too many hours, way too many, researching and writing about, if, for example, the performance improvement plan or beating them. And the second one about negotiating severance negotiation agreements, two of the most important topics that we see in terms of the web traffic and podcast traffic we have. So check out employeesurvival.com and see if this can try to help you, and you don't need an attorney to use it. Thank you.
Okay, so let's walk through the steps. First, the prima facie case. The only thing in dispute was whether her firing gave rise to an inference of discrimination. How did the court say she met that low bar?
The court pointed to 3 key things, all drawing on the circumstantial evidence we've been talking about.
Okay, number 1.
The replacement factor. Despite PVH's whole obsolete position story, the court accepted that Marina took over at least some of her duties. In an RF case, that's enough. You don't have to be replaced one for one.
Just showing that your key duties were handed off to a younger person is enough to raise that inference.
Yes, it suggests the job wasn't really eliminated. It was just repurposed for someone else.
All right, point 2 is about the age difference. Linfante Hill was 54, Marina was 47. They're both over 40 in the protected class. Why is a 7-year gap still legally significant?
This goes directly back to a Supreme Court case, O'Connor. The question isn't whether your replacement is under 40. The question is whether you lost your job because of your age.
So it's about relative age.
It's about relative age. Age discrimination is often about replacing an older, more expensive employee with a younger, cheaper one, even if both are technically older workers. A 7-year difference is more than enough to create that inference of discrimination.
And the third point, this suggests her situation wasn't unique.
Correct. The record showed a pattern. There was evidence that another employee who was let go in the RIF also had his duties taken over by a new, younger hire.
So it starts to look less like an isolated decision and more like a strategy.
It suggests that PVH might have been using a legitimate business tool, the RIF, as a convenient opportunity to, refresh certain teams by swapping out older, often higher salaried employees for younger talent.
Okay, so she clears the first hurdle, prima facie case established. Then PVH gives its legitimate reason, the RIF. Now we get to the main event, pretext. This is where the real battle is.
This is it. And this is where PVH's case completely unraveled because of the sheer weight of all the evidence suggesting they were being inconsistent and, frankly, deceitful.
And just to be clear on the legal standard, she didn't have to prove the whole RIF was a sham.
No, not at all.
Just that in her specific case, the RIF was used as a pretext to get rid of her because of her age and replace her with Marina.
Exactly. And her legal team's strategy was just brilliant. They focused laser-like on every instance where PVH's story changed or was contradicted by their own documents or just didn't add up.
When a defendant's story keeps changing, the jury and the judge, they lose faith.
They lose faith in the whole narrative. Let's start with the hard numbers, the statistics, because they paint a really dramatic picture of who this RIF actually hit.
Okay, lay it out for us.
The statistics are just stark. They completely undercut any claim of a neutral process. So there were 16 employees terminated in this RIF.
16.
Of those 16, 14 of them, that's 87.5%, were over 40.
Wow.
It gets worse. 12 of them, a full 75%, were over 50.
And the average ages?
The average age of the employees they terminated was 55 years old. The average age of the employees they kept was 47 years old.
An 8-year gap in the average age between those who were cut and those who were kept. Legally, what does a disparity like that do?
Legally, it's powerful circumstantial evidence. I mean, statistics alone don't prove intent. But when you combine them with direct evidence of replacement, like we have here, a jury is absolutely allowed to look at those numbers and conclude that the selection process was tainted by age bias.
It moves the claim from, my boss had it out for me, to the company was targeting people my age.
Exactly. It suggests a systemic issue. Now, PVH's defense was that these cuts were about the role, not the person. But the plaintiff just meticulously tore that apart by highlighting all the internal inconsistencies.
Let's walk through them because this really speaks to the company's credibility.
Okay, let's start with a small one that's still revealing. The age gap distortion.
Right. PVH initially said the replacement, Marina, was only 6 years younger.
Right, trying to minimize it. But the plaintiff's math showed it was actually 7 years and 4 months. It's a small thing, but it's part of a pattern of, let's say, massaging the facts to look better. It chips away at their credibility.
Okay, what's next? The whole foundation of the RAF, the economic factors?
This is a huge one. If you're claiming economic necessity, your manager should be able to explain the economics. But here, the senior managers involved. They couldn't.
They couldn't explain the specific financial reasons for the cuts.
Not in any detail. Mahoney and Kilgallen apparently gave vague and unconvincing testimony about the specific economic factors used. They couldn't clearly articulate the financial rationale beyond, we need to cut costs. If the people making the cuts can't explain why, a jury can infer the reason was just a post hoc justification.
A story made up after the fact. Now let's talk about that big project, the Center of Excellence, or COE power plan. PVH claimed this project was non-existent when Marina started.
This is a direct contradiction of documented evidence, and it's a jaw-dropper. They claimed it was non-existent to justify needing Marina's special modeling skills to build it from scratch.
But that wasn't true.
Not according to Linfante Hill. She presented evidence, including testimony from her own direct report, showing that she and her team were actively working on the COE, that it was going well, and was on track when she was fired.
So why would PVH lie and say a key project was non-existent?
Because admitting it was active and successful would make her termination and her replacement by Marina look completely indefensible. It's an attempt to erase her contribution to justify their decision.
And gets even worse, legally speaking, with what you call the inaccurate answer. This is in their actual court filings.
This one is just stunning. In their formal sworn answer to the complaint, PVH stated that Rosanna Bryam, who was Linfante Hill's direct report, started reporting directly to the manager, Lisa Kilgallen, after the termination.
The implication being that the team was absorbed upwards, not handed off to a replacement.
Exactly. It supports their story. But then, under oath in a deposition, Kilgallen admitted that Briam now reports to Marina. She admitted the statement in their official court filing was inaccurate.
Wait. The company filed a legal document saying the team reported to the manager, but the manager later admitted under oath that the team actually reports to the younger replacement.
Yes.
That is a massive credibility problem.
It's more than a problem. It suggests a conscious effort to mislead the court about the direct replacement nature of Marina's role. A jury is going to look at that and see intentional concealment.
And it seems like there was a similar issue with the timeline of when Marina's job was even approved.
Another inconsistency. PVH tried to make it seem like they started interviewing Marina before they knew about the RIF, to make it look like two separate, unrelated events.
But the timing didn't add up.
No. Internal finance people admitted they approved Marina's position after the RIF plans were known and approved. This timing matters because it suggests they weren't just searching for talent, they were lining up a replacement before they had even told Linfante Hill she was being let go.
Okay, and finally, the whole stated goal of the RIF to create a leaner organization.
But their actions contradicted that goal. During the exact same RIF period, the CIO's team and the Information Security Department actually increased their headcount.
They were hiring people while supposedly making cuts to get leaner.
Yes. And they couldn't even produce the documents to justify why information security was excluded from the RIF in the first place. It raises serious questions about whether this was a true structural RIF or just a series of targeted personnel decisions disguised as one.
So when you pile all of this up, the statistics, the direct replacement, and all these specific instances of contradiction, it creates a narrative where a jury could easily believe age played a role.
That's precisely what the court found. The court didn't say PVH was guilty. It just said there are so many inconsistencies, so many moments where their explanations strain credulity that they can't possibly say, as a matter of law, that this was just a neutral business judgment. When a company's credibility is this damaged, it has to go to a jury.
And there's one last pillar to her argument that really hammers this home, the direct comparison of her qualifications versus her replacements.
Right. PVH claimed they needed specialized skills she didn't have. But she argued she was clearly better qualified than Marina.
And this is where the technical details become really important for proving pretext.
Absolutely. If an employer fires you for a skills gap and then hires someone who is demonstrably less skilled, their whole rationale crumbles. It looks like a lie.
So Linfante Hill's expertise was deep in SAP implementation, these huge enterprise projects.
Yes. She had a proven track record of successful, large-scale SAP deployments in Japan, Hong Kong. She was leading the charge on the critical China and Asia deployments right before she was fired. These are the crown jewels of corporate transformation projects.
And what was Marina's background in that specific area?
This is the key. During his deposition, Marina himself admitted that he had only a little bit of SAP ERP experience.
A little bit.
You have a leader with years of success on your most complex technology being passed over for a replacement who admits to having only marginal familiarity with it.
So the company says we need a specialist and then they hire a generalist. It just doesn't add up.
It makes their stated reason for termination, the need for new skills, look transparently false. It strongly suggests they were prioritizing something else over actual qualifications.
And to really drive the point home, her legal team brought in evidence about what happened after Marina was hired, his alleged poor performance.
Right. And this is admissible because it speaks to PVH's state of mind and the quality of their judgment when they made the decision. Linfante Hill argued that Marina came in and then failed to successfully complete the Center of Excellence project she had already gotten on track.
And the big SAP deployments?
Her argument was that the momentum she had built on the China and Asia deployments was lost or stalled under his leadership.
And there was even a claim that Marina himself was later terminated.
Yes. Now think about what that tells a jury. If the company fires a successful employee to bring in a better qualified one, but that new person then fails at the job and is let go,
it reinforces the idea that the original decision wasn't based on merit at all.
It's powerful evidence of pretext. It shows that the employer's stated justification for the hiring and firing was, in hindsight, factually flawed, which supports the plaintiff's claim that the real motivation was something else, like age bias.
So the jury gets to see this entire, messy, complicated picture. The successful executive, the sudden claim of obsolescence, the less qualified younger replacement, the damning statistics, and all their specific instances where PVH's story just didn't hold up.
Correct. When a plaintiff can show they were clearly better qualified, and you combine that with all the other evidence suggesting deception, it's just overwhelming evidence of pretext. The court had no choice but to let a jury decide.
So in the end, PVH's motion for summary judgment was denied. Despite being this massive, sophisticated company with top-tier lawyers, they couldn't convince a judge that this termination was free of any discriminatory intent.
It all comes down to that key phrase from the court, the cumulative weight of the evidence. It wasn't one single thing, it was everything together.
Right.
You had the replacement by a younger employee, her glowing reviews, the fact they never even considered her for the new role. The statistics were 87.5% of those cut were over 40.
And all the internal contradictions, the inaccurate court filing, the vague rationale, the shifting timelines.
Exactly. When you pile all of that up, the company's credibility is just shredded. The court had to rule that this case must go to a jury trial because they could not say, as a matter of law, that discrimination played no role, which is that incredibly high bar set by the NYCHRL.
This case really is a masterclass in how a seemingly legitimate, economically driven RIF can completely fall apart under legal scrutiny.
It's a lesson in corporate integrity, really.
Yeah.
You can say your RIF is about efficiency, but if your process, your documents, and your manager's testimony all contradict that story and suggest you're trying to hide something.
You turn a business decision into evidence of discrimination.
Precisely. The takeaway here is that the price of avoiding a messy jury trial is total, verifiable consistency. The second a company starts manufacturing facts or filing inaccurate statements to prop up a decision, they're no longer defending the decision itself, they're defending their own honesty.
It's a powerful point. So let's leave our listeners with this final thought. If a company as sophisticated and well-resourced as PVH can't keep its story straight about a reduction in force, if they struggle this much to defend their own timelines and documents, what does that imply about the transparency of these decisions at major organizations everywhere? Especially for workers who don't have the means to mount this kind of detailed legal challenge. It's a stark reminder that even the most powerful companies are, at the end of the day, held accountable to the paper trail they create.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own end at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.